May I please know? Item number 59, my lord, contempt matter. The order has been complied with, my lord. I am appearing for respondent number
For the
1.
petition
I am for the
Petition is there.
complied with. Item 59. That the order direction contained in the order is very fast. Right. Do you have a copy of that order?
Yes, no problem.
Copy of the indicating complied direction.
I am appearing for respondent number 1. Contempt.
Same. Yes.
Progress.
May please. Okay, I have documented item number 37 and 38 with due consent from the other side. Matter will be taken up on 24th of June. Lord.
Date you can't fix. Do you want a fixed date? We have to go to July.
July 22, Lord. 22nd July.
Which item?
37 and 38. In 37, I am for the response number 6 and 7. And in 38, we are for the petition.
37, 38. The request.
On-
Have you taken consent of the
Yes,
council
yes.
for the other side?
Yes.
Mr. S. Tekala for the respondent in item 37 and petitioner in item 38. Submit with the consent of third and then again
22nd July.
22nd July.
May I
Problem.
please, your lordship, I beg to mention item number 50. Lordship, item number 50.
50.
Yes, lordship. My senior is out of station. Kindly adjourn the matter for a day.
You are mentioning on whose behalf?
Lordship, SCKL, on behalf of SCKL.
Have you taken consent of the council?
Yes, lordship.
So, it may be
50.
Yes, lordship.
Yes, up to that. Prayer made out of interim order passed.
Highly organized.
May please, your lordship. Your lordship, I beg to mention item 29 and 30. Your lordship, here I am appearing for a petitioner. It was regarding cases for lifting of the scrap materials by the railways. They were not giving extension. Now they have given extension, so we would like to withdraw the matter on instruction.
Mr. R. Sharma, council hearing for the petitioner. Submits on instruction that dismissed or withdrawn
Problem. May I please, Lordship? I beg to mention item number 57. Lordship. Implement Lordship will file implement petition. Lordship.
you will file
Implement petition. Lordship.
item number
57. Lordship.
57.
2 weeks time may be granted.
Request of file.
Maybe. Item number 34, Lordship. The conducting advocate H. Sharma is not well. So,
Item
matter may be adjourned for the day.
Yeah. It is submitted. We are doing after 3 weeks.
May please, your lordship. My lord, I beg to mention item number 31, my lord. Item number 31, my lord. My lord, in this matter, there is some difficulty on part of the conducting council, my lord. So,
31.
my lord, a status quo order was passed on 4/11/2022.
You take the consent of the council for the
The small consent has been granted, my lord, from the revenue department.
okay. Item 31 adjourned for 3. Status quo order. Interim order passed earlier.
Deeply obliged.
May please, your lordship. My lord, yesterday, Honorable picked the matter on Friday. I have mentioned the matter, my lord, for lifting, my lord. On Friday, came, so he will not, in senior country, he will not be available. Kindly make it, my lord, on Wednesday, my lord, instead of Friday.
That is on 19.
Or, no, my lord, for
On 12.
12, yes, my lord.
Okay, well,
Yes, must completely.
you give the mention memo.
I'm giving.
May I please, Lordship? Lordship, I beg to mention item number 26. Matter may be adjourned for the day.
You are mentioning on behalf of the respondent.
No, Lordship, petitioner, I'm appearing on behalf of J.M.H. Chaudhary.
The item 26, the request of council. Listed after the
Okay, sir.
Please, your lordship, I beg to mention for listing a WPC for water
What is the subject matter?
subject matter is lordship PMI Pakka construction. PMY Pakka construction.
Order. Fourteen. Based on 14.
This from
Change
lordship,
the date to 14.
11th of
No, 14.
14.
Change it.
Lordship.
Yeah, please, your lordship. I'd like to mention for listing of WPC 6126/2023.
What is the
lordship.
subject matter?
Land compensation.
Right,
Any day. Next
14.
obliged lordship.
Lordship, item number 61, your lordship, that's a contempt matter that was filed. Now, in terms of that matter, the Jimma vehicle was supposed to be released to us, is now been released. So the matter can be closed.
Item 61 is submitted by Mr. R.B. But that the order direction contained in the order dated passed in the that it applied. Therefore, that look take it forward, the medical method, this court does not wish to carry the contempt proceeding that is further then close notices withdrawn.
Extremely good.
May it please your lord. My lord, we have filed this application under 11(6) of the Arbitration Conciliation Act, my lord, praying for appointment of an arbitrator, my lord. The clause in the arbitration, the clause in the agreement is clause 23, my lord. It is at page, my lord,
Arbitration.
30 of the application. my lord.
Page 30.
Yes, my lord. The MOU was executed, my lord, in relation to a packaged water drinking plant.
Clause number
23, my lord.
now what has happened after that?
Now, lordship, after this MOU was signed, my lord, we handed over them the packaged water drinking plant, my lord. Thereafter, lordship, one supplementary MOU was executed on 16th of July 2020, my lord, which is at page lordship 32. Now, lordship, may we please to come to page 34, my lord.
32.
Yes, my lord. The supplementary MOU starts at page 32, my lord.
Yeah.
And lordship, may we please to come to page 34, my lord. May I read the second paragraph, lord?
Yes.
And whereas the sellers have entered into MOU dated 15th of June 2020, expressing their desire of retiring from the state firm and to hand over the firm to the buyer. The buyers, having relied various representation and warranties given by the sellers in the said MOU, had agreed to become partners in the said firm, enabling the sellers to retire from the firm, my lord. Now, lordship, in terms of that MOU, the original partners, my lord, they retired from the partnership firm, and the new partners were bought in, my lord. Now, lordship, we please to turn to page 35, my lord. Clause 4. The sellers have been unable to renew all the expired licenses, permissions, registrations of the firm. More specifically, the license from the Central Groundwater Authority, Pollution Control Board, etc. till date. The buyers have decided to withhold an payment of rupees 10 lakhs out of the agreed valuation as per the said MOU till such time the said licenses, permissions are obtained to the satisfaction of the buyer. Now, out of the total consideration, my lord, they did not pay us 10 lakhs. Thereafter, lordship, we issued them one legal notice, my lord, which is at page, my lord, 72.
Page
72, my lord.
72.
Lordship.
Yes.
Lordship, may I please to see clause 2, my lord, at page 73. That in terms of clause 4 of the supplementary MOU dated, you are liable to pay outstanding consideration amounting to rupees 10 lakhs, which comes to rupees 10 lakhs and 20,000 after interest, my lord, and therefore you are called upon to pay this sum of interest is lordships 1,20,000, and therefore the total amount is 11 lakhs and 20,000. And total claim was of lordship is at page 75, my lord, 26 lakhs.
So this dispute has arisen between whom?
Between lordship, the petitioners herein and the respondent, my lord.
Who are they insofar as the agreement is concerned? Who are these parties in
My
the
lord,
agreement?
in the agreement, my lord, I am the seller. The respondents are the purchaser, my lord.
No, you are referring to the arbitration agreement. Where is the arbitration clause?
Clause
23.
Clause 23, my lord. In the
Clause
MOU dated,
23 is what? Is
Lord.
a part of
this is the
MOU.
part of MOU, my lord.
MOU.
MOU.
Now the dispute is between whom?
Between the petitioners and the respondent. The respondents, my lord, they have also replied to my legal notice, my lord, saying that at present it can be amicably settled and there is no need for appointment of arbitrator. But lordship, amicable settlement was not arrived at, my lord, and therefore lordship, we have
Was
approached.
it initiated?
Lordship,
Was any settlement process
my
initiated?
lord, only the talk was initiated, my lord. They did not, my lord, go ahead with the talk, my lord. Their reply is at page 84, my lord. May I read clause 2, my lord, may I read paragraph 2 of their reply, my lord? It is at page 84.
Yeah.
That my clients are not agreeable to suggestion for appointment of an arbitrator. The appointment of the arbitrator is to be done on mutual consent and agreement between the parties. My clients protest the appointment of anyone, including learned advocate so and so, for two reasons. Firstly, the dispute which you have talked about is all creation of the brains of your client. They have withheld the valuable documents, the list whereof I am enclosing for your perusal, with a request to direct your clients to hand over the same to us. This exercise will resolve all the pending issues, and my clients will sit for any meeting if there is any genuine grievance of your clients against my clients to resolve amicably without intervention of anyone else. Secondly, the reason for opposing the appointment of so and so is on the ground that my clients have never been consulted about his name by your clients. If at all arbitration become a necessity,
Yes, heard. Steps supported by usual courts registered. After the
Inadvertently, I mentioned a item in court number 1 before the Chief Justice, Lordship.
Can be helped. We have
Yes.
already started the board.
Yes, Lordship.
We have already started the board.
Inadvertently, I mentioned allowed, Lordship.
No, no, no.
But
We
I-
can't.
on
We can't
Monday,
allow
matter
you
was-
now. We
That-
can't allow you
that-
now.
My opposition will be at surface, Lordship. Item 39 is mentioned on Monday, Lordship. I have filed IA, Lordship. I inadvertently thought that the matter was listed before. On Monday, it has come, Lordship. IA, I have filed only for vacating the stay or Lordship.
It has come before which court?
Lordship, before your Lordship on Monday 39, Lordship.
So what
Item
you,
39, Lordship. Today I filed IA, Lordship. Already filed, Lordship.
you mentioned on Monday, we'll see what happens.
Monday, Lordship. Oh, deeply obliged.
may please your lordship. In this matter, and on last occasion, your lordship, statement was called for.
Any instruction?
Yes, but it has been transferred to Silchar Police, the matter.
So he is agreed by his
Freezer.
freezer, yeah. What instructions on that?
That the transaction happened in Silchar, therefore there was an application by the IO here in the court of the learned Chief Judicial Magistrate, and the matter has been transferred to Silchar, my lord.
Then you bring it on record.
My lord.
Bring it on record. Whatever.
Maybe it should, my lord. Maybe.
Yeah, third learned counsel part. It's,
Respondents number 1, 2, 3, 4, and 5.
respond. 1, 3,
4, and 5.
Within a course of this week, steps on respondent section 7 by the court and registered within month.
Obliged.
And
Please
Dusty also, my lord, for respondent section 7.
Dusty is also part of it.
Hello,
Related to the registry of the act.
My lord, the petition is a tenant under number 6, my lord. Code 28/124. My lord, the respondent lady, my lord, the respondent 6, my lord, she came with the antisocial elements, my lord, and started demolition of the premises of the premises.
You have already filed a suit.
I filed the suit, my lord, but and my lord, the learned court below also, my lord, directed the landlady to restore my possession, my lord, by order dated 29/124. With the help, if the she did not, then with the help of police. My lord, on being came to know about this order dated 29/124, my lord, the landlady completely demolished my premises, my lord, and taken away all my articles. Page 56 is there. 56 is, my lord, my list of articles. My lord.
No, what is your prayer now?
My prayer is, my lord, the police. My lord, the police has not registered even a case, my lord.
Police are not registering. You have ample avenues under the criminal procedure. Why don't
No, but my lord, the allegation in my FR page 53, my lord, clearly make out a case for theft, my lord. If it is a case of theft.
if your FIR is not registered,
My lord.
you have remedies under the criminal procedure. Why have
156.
you not? Why have you not?
No, my lord, 156.
Taken reports?
I have the remedy, my lord, but my lord, I informed that even the superior authority of the police also, my lord. But my lord, even the police has, my lord, it is a mandatory on the part of the police to register a case and my lord, investigate the matter, my lord.
But we want to know, have you taken records under CR?
No, I'm not.
You should.
No,
For
but my lord, 156 is apart from 154 is my lord mandatory. And Honorable Supreme Court also, my lord, in the case of Lalita Kumari
reported in 2013-14 SEC.
We are aware of it.
Yes.
But for every case, that
No, the note for every,
you have
my,
to tell
my
us
lord,
why, what stopping from making reports and how this remedy under CRPC is not adequate for you.
but my lord, whether my case is not, my lord, how, my lord, a tenant can be, my lord, by demolishing, the articles can be taken away by the landlady, my lord. Suppose,
get-
my lord,
get your
my lord,
instructions.
my lord, suppose I file a petition under 756, my lord. Even then, my lord, the police will not, if the police is not going to take any action against that, then, my lord,
That is an apprehension you are
oh,
expressing.
no, not
You
a
have
petition.
not
My,
filed
my lord, in my FIR, I have made categorical allegation against 2 police persons, my lord. And I have lodged a complaint.
Where is your FIR?
My lord, page 53.
Page number.
Yes, my lord, page 53, my lord, annex G. 53. Merit. And page 54, second para, my lord, I made a clear a categorical allegation against, my lord, one Mr. Achyut Nath and one.
This FIR has been received. Has been received.
Yes, on, my lord, I lodged it, my lord, I lodged in second, my lord. They received it on fourth, my lord. 2, 3 days.
Please find out what steps have been taken pursuant to this FIR.
Indeed, my lord, but as has fallen from this honorable court, my lord, whether at all, my lord, the prayer, direct the police to register an FIR.
No,
That is the
first-
prayer,
first
my lord.
find out what is the status. There is an FIR which is received. If they have taken steps, please intimate the court.
Lordship, that instruction I
Yes,
will do.
that only that
Now-
instructions and how the police have acted upon this FIR,
Yes,
if
my
at
lord,
all.
how it has been handled, my lord.
That's all.
My lord, then, my lord, then, my lord, on 7th of February, the police called this petition, my lord, and they 63, my lord. They asked the petition to sign this letter, my lord. This letter says, my lord, that he has received the possession of the enforcement of the order dated 29/1, my lord. It means, my lord, police is clearly acting at the hands of respondent 6, my lord. After demolition, what this letter, my lord, says?
Why did he go and sign it?
No, I did not sign, my lord.
Then?
No, why should I sign, my lord?
Where is that letter?
Page 63, my lord, type copy.
63.
Last page.
Huh.
On the strength of this merit.
This has not been signed.
No, I did not submit because, my lord, there is even nothing to be taken taken possession, my lord.
All right. Please get the instructions.
I'll send
Heard.
an extra copy if you may.
Yes,
Couple of.
Petitioner is agreed by the fact that in spite of the injunction order passed by Court of Court of the Civil Judge Union Division number 1 and Guwahati, site number 5, 2024, along with injunction application in Miss J case number 4 of 2024. The landlady of the premises in which the petitioner claims to be a tenant had taken over possession, demolished the premises and taken away all these articles. So, being agreed, he has lodged an FIR dated 2/2/2024 before the officer in charge, Sultan Bazar Police Station, which was received on 4/2/2024. So, however, petitioner submits that no action has been taken, and as on date, to the best of the information of the petitioner, the FIR has not been registered. So, Para MSS Sharma, learned government advocate, permitted to obtain instructions as to the steps undertaken, if any, by the concerned police station on the basis of the FIR stated to have been lodged by the petitioner. In order to facilitate the learned government advocate to obtain the instructions, the extra copies be furnished within the course of the day.
That's
Matter will be listed again on
some crime branch.
14th. 14 June.
Well, like. In this case, Your Lordship, on 4/2/2021, the husband of the petitioner had expired due to road traffic accident in public place. And after that, Your Lordship, petitioner submit application supposed to get as gracia relief from the concerned authority.
Have you enclosed the legal year?
Yes, Lordship. Annexer 4, that was 23.
I heard counsel for the parties issue notice and 4 weeks. And it's Sharma, Abhinar Kher appears on behalf of respondent. 3, 6. Mr. P.R. Monto for respondent 1. Mr. P. Gogoi for respondent. The respondents are represented by the respective counsel, which is the waiver of extra copies regarding 1 week from today. Let the respondents complete their instructions and file necessary affidavit, if so advised in the meantime, and to be listed after returnable date. Yes, Mr. Sahu.
Hello. Actually, the petitioner is a taxable service provider, and he is regularly paid his service tax from, and his books of accounts have already been audited from April 11 to March 2016. Despite of the fact in 2020, one book has been issued on the basis of income tax form 26A, keeping all the transactions as a turnover and full rate of tax has been charged, amounting to 1 crore 52 lakhs 935 without authority of law. The petitioner repeatedly brought the notice of the adjudicating officer, state the provisions of law that works contract service provided 50% RCM and 50% taxability, they have discharged the tax liability. Despite of the fact, whole 26 form 26A transaction has been taken as turnover, and 15% at 12.3 and 15% tax has been imposed on that. This is completely without authority of law. So,
Where is that order?
order, my lord, order, page at 94, annexure 10. Extended period of limitation also included here in this order.
Page 90?
94, start from 94.
Where is the bar that is done?
Yes, sir. Yes, sir. I will come. Yeah.
Issued on this information collected from the income tax
Yes, sir.
department. And what is the jurisdictional error?
At page now 102, paragraph 20, it is evident from the detailed mention in the above table that the total service likely for the 1415 to 1718 was rupees 1 crore 62 644. But the notices paid service tax 18 lakhs 26 696. As per the through GR7 challenge, and was a short payment of service to the 1 crore 52 35. My lord, here in this table is mentioned 1415 to 1718 total gross received scores as per form 26A. As page number 102.
Yes. So why not file an appeal?
My lord,
Why not go for an appeal?
my lord, actually the 7.5% pre-deposit condition is there, and it's not possible for me to go further file an appeal. So I filed this pre-deposit condition, pre-deposit.
How much?
Secondly, near about 10 lakhs is will come to 1 crore 50, 12, 13 lakhs, it will come 13 lakhs.
We direct you to deposit 20%. Deposit and go and file.
7.5% the pre-deposit, statutory pre-deposit before commission appeal. But actually, financial condition is not sound to find all these things. And this is completely illegality is there. So The
What illegality?
illegalities, service, works contract service attracts 50% of the total taxable service. Is a turnover or taxable turnover. But here 100% is we charge as per the form 26A. Secondly, whole amount, whatever from 1st April 11 to 15-16, audit has been completed. There is no dispute on that, but that audit is included as a extended period. Page number, my lord, see at 81. That has been audited and proceeding is closed at page number 81. And the relevant point is page number 84.
No, but in view of the statutory appeal, why should we?
Yes, actually that is completely illegality, my lord. So whatever is the legality,
Unless
I would go for it.
You have referred to some jurisdictional error. What is that jurisdictional error?
Jurisdiction, my lord, here the joint commissioners issue the proposed notice and he has no authority to issue without going the provisions of law, without considering the provisions of law.
What is that provision of?
Provisions of law says taxable turnover will be determined as per rule 2A of the Return of Service Tax Rule 2006. Secondly, notification 30 of service tax says the water in case of work center service, 50% of the taxable turnover will be charged as a taxable by the petitioner and remaining 50% will be.
Who appears for the respondent? Yes, what do you say?
So, Your Lordship, my senior is out of station.
Who's your senior?
SPK also.
What can be done? You are here. You tell us what is to be done. You get your instructions. No matter. Heard letter counsel of the parties. The petitioner is agreed by the impugned order that impugned order dated 27/3/2024, whereby the following order was passed by the court. According to the petitioner, this order has been passed without following the provisions of law, and therefore the claim is required to be prepared with. Let the respondent obtain the required instructions. Meanwhile, the petitioner will also satisfy the court by the court should exercise jurisdiction in view of statutory remedies being prescribed in the statute. Let the matter be listed again. When is he coming back?
After a week,
After a week. Let us have it on 19th June. We'll consider your interim prayer on 19th, not before that.
Mashallah,
Prayer
like,
for interim will be considered on the next day. Extra copies be furnished to standing now.
Lordship, I'm from restaurant number 1 on behalf of SME.
Yeah.
May I please the Lord? The present petitioner, my lord, is a registered owner, my lord. He purchased the land, my lord, in the year of 1985, my lord. He has the sub-register also is a certificate having his possession certificate, my lord. But since, my lord, in the 2018, my lord, he has come to know the change on same plot of land, the purchased land by the petitioner, my lord, the different dark numbers of personal numbers are found. Some land mafias are trying to get this land. In that matter, petitioner lost an affair. After one filing application, ultimately one demarcation case has been registered. And demarcated in 2020, my lord, and the circle officer issued notice, but till 2020, then even last notice 2023, but no action has been taken, my lord. I am apprehending, my lord, the same plot of land, two different dark numbers, two different pattern numbers.
some other persons trying to sell of this land, and even I have made an objection into that. Lordship, kindly have a look on page 16, my sale deed, first. Page 16, annexure 1, my lord. It's a type copy. The original one is
16?
16, my lord.
Yes.
Yes. Lordship, Lordship will find here that number, my lord, in the. My name is Amitesh Gupta, my lord. That number is 5354 in the Center, and then it's the patta number 14, my lord. This is my purchase land, that number and patta number here, my lord. Then, my lord, page 32, annexure 4. This certificate issued to me by the senior sub-register Guwahati, my lord. It is on 18/8/2008, my lord. It is from the certificate, my lord. It is a patta number 14, tab number 5354, area 9, 1 kata 9 less. This is my land, my lord. Then, my lord, page 5, page 33.
What is your prayer before the court?
Yes, my prayer, my lord. Page 10, my lord. Kindly have a look. Annexure 10, I will take your lordship my prayer. Annexure 10, page 47. This is the demarcation application for demarcation of land, my lord, to inquire of the map. Why on the same plot of land, why two different tax numbers, why two different patta numbers, my lord? This is ultimately, my lord, I raise all the my objection here in this case. Ultimately, my lord, page 49, one land demarcation case has been registered 204 19 and 20, page 49, my lord.
Yes.
Yes. By this notice issued, my lord, 7/3/2020, my lord. Then, my lord, finally, my lord, very last phase of my annexure, my lord, after 2020, my lord, no action, my lord. Finally, another notice, my lord, at page 56, annexure 16, my lord, on my land demarcation case, my lord. Till date, my lord, only notice process is going
Why
on,
don't you file applications before the concerned DC?
my lord.
Why don't you bring it to the notice of the DC? It is the DC.
My lord, the respondent to is deputy commissioner is also one of the party in this matter. Why?
I know, but why have you not brought it to the notice of the DC?
My lord, since this matter, circle officer respondent number 3 is taking up this matter, my lord.
Correct, but he's
Yes.
not proceeding in the matter according to you.
My lord.
DC is the next higher authority. You should bring it to the notice by filing necessary application representation.
Lordship, it's correct, lordship. And lastly, my lord, one document, my lord, I'm apprehending, my lord. And page 50 to annexure 13, my lord. One applicant, one Nomita Kolita, on same duct number, patta number, my lord, trying to sell the my concerned land, my lord.
You should have filed it before the DC. Proper matter. Why have you not filed it? Ultimately, the records are available there only.
Then lordship may give direction to the for that we file an application, deputy commissioner and deputy commissioner look into the matter.
Third learned counsel for the party. This reputation is filed by the by the action of the circle officer Kamluk Metropolitan Review Circle in respect of an application filed by the petitioner dated. What is the date of the application?
Yes, my lord. That is
11/9.
11.
2019.
Yes, my lord.
2019. Pursuant to this, a demarcation case was registered and notices for
My lord, 16/9, not 11.
16/9.
Yes.
2009. Pursuant to that demarcation, land demarcation case number 04 of 1920 was registered and notices were issued to the parties, including the petitioner, by notice dated 7/3/2020. However, no steps were taken by the circle. Subsequently, the petitioner filed an application before the DC sale permission sought for by some person who is claiming state land of the writ petition to be her land. So the description of the land of the writ petitioner is what is the size of the land?
Lot.
What is the size of the land?
Malo, 1 kata,
Measure
9 lesa.
1/4 9 letters covered by tag number 6, Patta number 101, situated at village Maligaon, Mukta, Jalukbari, and the
My lord. In NHF 14 million, our representative, we have made also copy to Deputy Commissioner also. Page
the
54.
petitioner filed objection to the sale permission sought, and a notice subsequently was issued on 28/12/2021 for hearing the objection. So, however, no order has been issued by the concerned officer. Petitioner has been repeatedly filing his appeals and objections with certain documents, with copies marked with the approvement. The court of the the petitioners also have filed necessary can file necessary applications before the seek approval. In respect of the grievances of the writ petitioner that the land demarcation case refers to was initiated by the federal officer, either has not been proceeded or some order has been passed, copies of which are not available or served on the writ petition. So the petitioners are therefore permitted to file a detailed application with seek approval, and upon such an application being filed, the DC will examine the matter and pass necessary orders, and if required, direct the circle officer, approve metropolitan, approve revenue circle to take effective steps. Is it Kamrup revenue circle?
Kamrup, yes, ma'am.
Not Kamrup, it's Guwahati revenue circle.
Guwahati,
Circle officer, Guwahati revenue
Guwahati
circle, Kamrup. Pass effective orders.
Yes.
On such any such application, any such matter which is pending in respect of the land claimed to be that of the writ petitioner. The petitioner is permitted to file the application within a period of 2 weeks from the date of receipt of a certified copy of his order, and the DC thereafter will dispose of such representation within a further period of 4 weeks from the date of receipt of such application before the DC. With the above observation, writ petition stands
deeply obliged.
This is against the rejection of the application for refund under section 15B of the Central Sales Tax Act. The similar matter pending where notice has been issued. We are also going to.
Lordship will issue notice matter. I would like to file an affidavit because it will have to be decided in the fact of his own case.
heard.
Impugned order is page 149.
It's submitted that particular matters are pending. And the matter is squarely covered by order dated 31/10/2020, passed in the BPC State Board of 2020. Mr. B. Gogoi, learned
Holder has come.
appeal on behalf of
120.
one. As such, notices on the respondent the waive, however, extra copies be furnished within a period of 1 week. from date. Matter be listed. Along
After
with
vacation, not along with, I will file my affidavit in this case. Those are coming up on 20th, I suppose, 20 or 21st.
Yes.
Others also, my lord, it won't be over by before the vacation. Let me file my
let
affidavit.
the matters be listed in July. Meanwhile, the respondents will complete their
Both 7 and 8 same.
instructions and file necessary affidavit in the matter.
8 is also similar.
Same.
Yes. Okay. Similar.
Well, here the company went into the insolvency, resolution plan was approved by the NCLT. Now the income tax department is sending notices for recovery of the amount for the period prior to the process of resolution process. Now the matter is squarely covered by the decision of the apex court, when it said that the recovery of the demand, any tax demand from the either central government or state government cannot be made for the period prior to the process of resolution of approval of the resolution process. Here the 12, 13, 13, 14 below, the authorities are going for making assessments and again sending me notice for the recovery. And the notice for recovery now recently I have received. I placed before lodging the Supreme Court judgment also. At page 195.
Yes.
For assessment year 13, 14 and 12, 13 Milord.
Yes.
Whereas Milord, the resolution was approved. You'll also find at page 100. And order dated 19th June 2020, Milord. You'll also kindly see the similar with the pending asset, right? You'll also kindly see Milord page 675. Two point one, the question which arose for consideration for the apex court, as to whether any creditor, including the central government, state government, or any local authority bound by the resolution plan, once it is approved by the adjudicating authority under subsection 1 of section 31 of the Insolvency and Bankruptcy Act, referred to in so and so. After discussing, you also find here the demand was on account of the sales tax at page 7, para 17, you'll also may see.
My lord, similar issue has been raised in another batch of petitions. Those are pending, my lord. So let the notice be issued and matter may be tagged with the other matter.
Well, the impinged order of recovery has to be stayed because they cannot make a recovery. The Supreme Court judgment is likely there.
Which paragraph in the judgment?
Melody, I'll also see paragraph concluding program. My lord, I will give the reply at page 716.
Yes.
Your Lordship may see para 138. Period prior to the approval, my lord, it has been held that which are not a part of the legislative process will stand extinguished.
Para number
38, my lord, at page 726.
So these claims were not a part of the resolution.
Well, no,
These claims raised by the income tax.
no. Or the public notice was issued, but this was not, they have not made any claim. In fact, my lord, if you lost
They
it,
could have approached the NCLT for.
no, my lord, the court has also dealt with that much
Hmm.
at para 139.
No, I'm talking about the.
NCLT we cannot move because the NCLT
Not you, the department.
department also, my lord, the process is that once it is approved and everything claim has been, the company has been taken over. Thereafter, my lord, it cannot be, because whatever resolution process was there, the amount was fixed. On the basis of that, it was taken over. If you also just look into, my lord, conclusion para 102, or at page 716. May I read, my lord?
Yes.
That once a resolution plan is duly approved by the adjudicating authority under subsection 1 of section 31, the claims as provided in the regional plan shall stand cogent and will be binding on the corporate debtor and its employees, members, creditors, including the central government and the state government, on the local authority, guarantors, and other stakeholders. On the date of approval of the regional plan by the adjudicating authority, all such claims which are not part of the regional plan shall stand extinguished, and no person will be entitled to initiate or continue any proceeding in respect of a claim which is not part of the regional plan. Para 1023, my lord. Consequently, all the dues, including the statutory dues owned by the central government and the state government or local authority, if not part of the regional plan, shall stand extinguished, and no proceeding in respect of such dues for the period prior to the date on which the adjudicating authority grants its approval under the scheme could be continued. Now, this was approved in 2022. With 100, my lord.
Yes.
And these are for 12, 13, 14. Otherwise, the purpose of the, my lord, the approval of the resolution plan and all this taking over,
The expedition process has already started.
it is completed. Completed, and I have already taken over.
Where is the notice?
You will notice, you will also find the last, after the assessment orders, I have annexed all, but ultimately the demand notice has been received. That comes page number. At page 195, million.
$195. Yes.
You also find in the first column, assessment year. These are all periods prior to the approval of the resolution plan.
Sorry, staff and the council assisted by Ananda and Mr. SCPL and council. Income tax. You're for all the rest.
In fact, in another case also a stay was there, he should have pointed out to your lordship.
Hearing for the respondent. The petitioner. The company has already been liquidated.
My lord.
Company.
Liquidated and the name remained, my lord. I have liquidation is not there, my lord.
Huh.
Liquidation is separate.
Just
process.
resolution.
Insolvency. And on the basis of resolution plan, I have taken over.
The petitioner, you have taken over which
The company, my lord.
company?
This is same company.
The petitioner before the court make a challenge. This is the notice at 195.
My lord, 195 notices, the others are, all orders are there. In the prayer, my lord, I've given all the details, the orders also. But, my lord, ultimately the demand notice is there.
Is agreed by the several orders passed by the public authority, namely page 31, like order number 12 for the various assessment year, and finally a demand notice been raised demanding total amount of 8,18,41,586 for the assessment years 2013, 2012, 2014, as per the demand
12, 13 and 13, 14.
12, 13 to 13, 14 by notice dated 4/9. Learned City Council and company underwent that the NCL by order dated
Page 100.
19th of June 2020 in case number so and so passed an order under the Insolvency and Bankruptcy Code 2016 accepting the resolution plan, the proposal as submitted before the court, before the NCL.
And I have taken over, my lord, the management on 27/6/2020. At page, petition, my lord, paragraph 11.
The resolution plan approved by the NCLT is to be following with the following directions, page 105. The present set of directors have taken over the company with effect from
27/6/2020.
27/6/2020.
My lord, para 11.
2020. So, Learned council, senior council to the petitioner submits that once the resolution plan is approved, no further claim in respect of the company can be proceeded other than those mentioned in the resolution proposal. In resolution proposals approved by the NCL. So, in support of its content, is rapid judgment of the effects
Para 102.
rendered in Ghanshyam Misra and Sons Private Limited, reported in 2021 9 SCC 657.
At page 716, my lord, para 102.
Referring to the said judgment, that is senior counsel submits that once the claims as provided in the resolution plan are approved, the same shall stand frozen and will be binding on corporate debtor, its employees, or members, creditors, including central government, any state government or any local authority, guarantors or stakeholders. So, he submitted on the
1023
date,
also, Lord.
the date of approval of the resolution plan by adjudicating authority, all such claims which are not part of the resolution plan shall stand extinguished, and no person will be entitled to initiate or continue any proceedings in respect of the claim which is not part of the
My lord, for the period prior to it mentioned in 1023, my lord.
He submits that the demand which has been raised by the orders and by the demand notice are all prior to the period of the resolution of the orders passed by the NCLT approving the resolution plan, and no such claim has been placed before the NCLT during the hearing of the resolution plan.
My lord, in
Prior
fact, the
to
orders been passed subsequent to, my lord, the, now in 2022. But my lord, the Supreme Court said that for the periods prior to, in 1023, my lord.
so he submits that all these demands which have been raised are all relating to periods which are prior to the order passed by the NCL approving the resolution plan. He therefore submits that the impending orders need to be struck down and the demand notice along with the demand notice and during pendency the proceedings to be stayed. But Mr. S. Setia, a learned standing counsel in complex. What do you submit?
My lord, we'll file affidavit, my lord. In fact, my lord, this
Submits that similar matters are pending. You would like to complete instructions and file that with the affidavit
Lord.
in the matter. Accordingly, let notice be issued returnable 4 weeks since Mr. Setia appears on behalf of the respondents. This is a waive our extra copies of verdict in the period of 1 week from today. Until further orders, the impugned orders passed by the income tax authority being numbers so and so, so and so, as well as the demand notice dated so and so shall remain state.
Actually, the demand notice, my lord.
Yes.
I know, I am obliged.
Yes.
I have for respondent number 6, Lord. The petitioners were directed to take steps upon respondent number 8 and 9, if I'm not wrong. They sought for CBI investigation. Lord.
In terms of the order dated 7/1/2022, steps were directed to be taken. Respondent number 9. Eight and 9. So, insofar as respondent number 9 is concerned, steps as directed have not been taken by the petitioner as per the office note dated 3005/2024. So, none appears for the writ petitioner also in the matter. However, in the Mr. Aloi appears for the
Respondent number 6.
respondent number 6. Insofar as that respondent number
4.
One, Union of India.
Union of 2 to 5.
purely but we namely to undertake steps that after
There's a direction to take the state to order respondent 6 because this is independent body. BTC has said that the commissioner town committee Gosaigaon. My lord, this petitioner is not in contact with me, and I don't know whether they have got a relief or not. The matter is that newly constructed municipality market, their space is less, and the notice was issued to BTC. So at this stage,
Learned counsel to the petitioner submits that in spite of
one
efforts.
chance may be given, I take an instruction, otherwise I withdraw, but clear cut instruction is not also with me.
You are withdrawing from the matter or not? You are withdrawing.
Actually, clear cut instruction they have not provided, so I pray that one chance may be given.
Learned
And that
counsel
they,
to the petitioner submits that he is unable to contact with the petitioner. Therefore, prays for further 3 weeks time to complete his instructions and take required steps.
Yes.
If necessary. Mr. P. Chaudhary appears for the PTC list after 3 weeks.
Obliged, ma'am.
But, two parties are to be involved, madam, every day. In the read petition, madam. I'm for the read petition, madam.
You are for the writ petition. Applicant.
Yes,
You are
ma'am.
for the applicant.
Yes.
Any objection?
No, your lordship.
No.
There will be
Heard, learned.
respondent number 8 and 9, madam.
Applicant is in an application. Praying for seeking improvement of measures Prakash Namasudra and Pradeep Das as respondents
Yes.
8 and 9 in WPC 3234 of 2021. Who are these persons?
They are the members of the board, my lord. I have challenged the board, my lord, notification, of common notification.
Where is the notification?
Notification is in, my lord, here I have not annexed, but in read petition,
The learned counsel for the petitioner submits that the petitioner applicant submits that the applicant, the petitioners have challenged the
notification, my lord, dated 7 February 2022,
notification dated 7 February 2022.
22.
What is the notification about for constitution of the
This
board?
is the notification, my lord, by which, my lord, the board has been formed for development of SC, my lord.
By which the
community.
subdivisional SC development board was
Yes, ma'am.
constituted. And the respondent and the opposite parties are members of the state board. And since the petitioners have challenged the notification, we submitted that they would be necessary parties and therefore are required to be included in the writ petition as respondents. Counsel for the respondent do not object to the prayer made. That view the matter. On taking into consideration the submission made and upon careful perusal of the pleading available for the court, this court is of the view that the prayer made in the IA can be allowed. Accordingly, the IA stands allowed. The petitioner is permitted to array so and so as respondent number 8 and 9 in WPC number so and so. Arrayed is respondent in WPC number so and so. Stop the petitioner will file amended post title within a period of 2 weeks. You have to file an amended post title before the registry within a period of 2 weeks. Writ petition be thereafter listed by the registry. In the writ petition, you write IA so and so has been in view of the order passed in IA so and so has been arrayed as party respondent. In the writ petition, petitioner is directed to file a post title within 2 weeks. And the matter be listed thereafter. Yes, I respond.
Notices will be, my lord, served after the amendment is made.
Yes, after you file the
Right.
amended post title.
Right.
Right.
Lordship, here I have been informed and instructed, Lordship, AG will address your Lordship. Lordship may take it up on 14th or 21st, Lordship.
Supposed to be covered.
No, by
You're placing reliance on
Lordship,
some others.
12 to 14. 12,
This was the case, my lord, where the
None of these matters.
The budgetary
amendment
support of
amendment was
resolution.
made and all pending applications which were not disposed or rejected. But the problem is that my learned friend will not, sometimes he starts says, I will argue, sometimes he says the AG is not there, and AG will argue, at least, your Lordship may remember, at least 7
We have
times.
heard this matter.
Lordship has heard the petitioner side. Lordship, I have been instructed, Lordship, either on 14th or 21st, Lord.
Let it be on 14th. Oh, 14th is can be on 13th.
13 will be difficult, Lordship, on 14th. Yes.
So we set the calendar as per our convenience. What can be done?
And
It's a
Lordship,
barter matter. 14th is a still in a day. I don't know whether we'll have time to take up again.
Lordship, let it be on 14th, then Lordship.
It is submitted on behalf of the state that the learned education.
Miscase help me.
They have to come.
Ram then to October.
But tomorrow.
Today, it's up.
Lordship, a miscase has been filed with regard to the
The writ petitions be listed along with all IS.
Well,
that
in one of the
we filed.
petition now they filed
there was a typographical error,
to
Lordship,
withdraw the affidavit in opposition. Now,
and to file refile. That's it.
now what they will file, my lord, again?
Only the
No, where is the IA? Is it listed today?
no, Lordship, it was filed on Monday. Lordship, that has not been listed. Lordship.
No, no. Let it be on.
Yes.
So last year fixed up on 14th.
They want it on 14th.
May I please, Lordship? Lordship, in this case, Lordship, we'll like to file affidavit, Lordship. We have received instruction, Lordship.
So if you like to file, you should file. It is a 22 matter. When are you filing your affidavit?
Lordship, 2 weeks, Lordship.
Yes, Dr. Saraf.
Well, instructions have been received. If I will not say anything, my lord.
Learned Counsel for the Petitioner, Mr. N. Polita, Learned Counsel appeared to be of the Industrial Department of that he would like to file affidavit on behalf of the instruction Industries Department. He prays for 2 weeks' time. The matter be listed again after reopening that. He listed after the month of July on a date to be fixed by the registry. In the 3rd week of July on a date to be fixed
No,
by
but
the
you
registry.
lost fix up the date for filing of affidavit. Otherwise, my lord, again,
No, we are fixing it in the 3rd week of July, by which time they will file it.
no, my lord, that means in the 3rd week of July, my lord, 8 weeks they have, 7 weeks they are granted.
All
They are
right,
paying for-
the Industries Department will file, you wanted 2 weeks.
Yes, Lordship.
Will file the affidavit within 2 weeks positively, and the writ petition be thereafter listed in the 3rd week of July on a date to be fixed by the registry.
Obliged.
Petitioners are permitted to file rejoinders to such affidavit as may be filed in the meantime.
Visual object. This case, so I instructed my client to bring the next of kin certificate. They have not yet submitted the certificate.
Mr. R.M. Chaudhary, Learned Counsel for the Petitioner, prays.
One more thing, Lordship, I kindly record it, that my lord, this incident has occurred in 1989. All the schemes that has been annexed is prior to, post my lord 1989. So whether you will be covered or not, from the notification, my lord, there is no retrospective effect.
Right, let him file the NOK. Next of kin he is not filed.
Lord,
How much time do you require?
2 weeks time.
Let it be 3 weeks. Permitted 3 weeks time, enabling him to file the next of kin certificate as directed by the court earlier on by the order dated 28/9/2022. Mr. P. Gogoi appears for the respondent.
My lord, Finance Department, my lord.
Finance Department, MS Sharma for
1, 4, and 5.
1, 4, and 5.
Extra
Mr.
copies have
Mutari.
not been given in the office.
Mr. Mutari appears for the PTC. The Standing Council will be furnished with the extra copies of the writ petition within the course of 1 week from today.
17 also same. Next 17 also.
All right, same order.
Master.
Please, your lordship, the government has not filed their affidavit.
Extra copy. Extra copy to दिया ना. Here for you. Extra copy for ना आपको.
Or maybe sometime maybe he can.
They've not furnished the extra copies. Here.
I understand the adjourn at the request of the council. It is listed after 4 weeks. MS Sharma for the respondent.
Affidavit they have not filed.
What date?
We are challenging the demand, my lord, made after delivery of goods by railway. In fact, matter is, my lord, covered by division bench that I have annexed.
Who's for the railways?
Nowadays, my lord, PGSC, they are aware.
Railway Standing Council
Nowadays, my lord,
is permitted to file their affidavit within a further period of 2 weeks. Mr. A. Goel, the council appears for the writ petition. Matter be listed after 3 weeks. Interim order passed earlier will continue.
That's similar issue, well, can it be on 13? They sought for some opinion, can it be on 13? Man?
What?
Only on that
Matter
point, man.
that we have the benefit of going through the file.
Yes, my lord.
Yes.
In fact, my lord, on the last occasion, there was a submission made, my lord, this series is covered by an order passed by coordinate bench.
Yes.
So, my lord, they have sought for some opinion, my lord, on 13, my lord.
What
Only
opinion
on
do you
that point.
want?
My lord, not only one judgment, thereafter 8 petitions more have been disposed of.
It's
Let
covered.
it be on 13, my lord. At least they have given a letter, my lord, they are verifying this part on 13.
What is there to verify? You verify, you are the council, you tell us.
No, my
whether
lord,
on
just,
this
my
file
lord,
it
the
is covered or
financial
not.
implication is there, my lord. Let it come from them, my lord. You can on 13, my lord.
No. If there is a factual instruction, certainly. But this is a question of whether these issues are covered by these orders. That's the thing
Yes,
that
but
you have
on
to find
13,
out.
I will place it, my lord. Either this way or
My
that
lord,
way.
another standing council on the last occasion said it is covered and it was disposed of.
Oh, Vikram.
No, Vikram.
I don't know.
It is covered by which?
Because the
One
Assam Gas
doesn't-
Company is the main judgment, my lord, and thereafter 7 petitions were disposed of. And one of the order I have given, my lord. No, hey.
The Pelagon order.
Well, this is the follow-up judgment. Main is Assam Gas.
Assam, yes. That's the main.
The Losimisi para 19 of
There
the
you appeared, Mr. Gogoi.
Yes, my lord.
Kamrup Port, my lord, in view of the aforesaid concession, the Losimisi para 18-19. Of the Pope. So submitted. Department custody and being submitted that the present case is covered by the decision of so-and-so in view of the opposite submission, concession made by the standing council, the council for so-and-so. In the case of Milot, Pope,
Cover it, Mr. Gogoi.
No, living on 13, I will make only one submission, my lord.
Not 13,
13, my lord.
not 13, not 13. You do it on 11. 11. Give you time till 11.
if it is not covered, Milot, we will never say that it was covered.
On 13, my lord, please. Please, some difficulty. on
You have to just, you
No,
had
I
argued in
understand.
this matter, your
I
name is
understand.
reflected, you are familiar with the subject
Yes,
matter.
yes. On
You
11,
require the,
some difficulty on 11, that's why 13 I statement, on 15.
not 13, 13 we are overburdened.
On 14, well, I will make only one submission.
Then it is on 10. 10,
10 Monday.
Monday.
Let it be, my lord, on, in that case, on, my lord,
12. All right, not beyond
12,
that.
12.
12, Wednesday.
Well,
Mr. Dr. Saraf appears for the petitioner, Mr. Gogoi, standing counsel
Thank you.
appears for the respondent, who prays for a day's time to apprise the court
No, no,
as
no,
to
fine.
whether the matters are covered by similar orders and judgment passed by the court in Bengal. Stop. In order to enable Mr. Gogoi to complete his instructions, the matter is deferred today to be listed again on 12th.
As to whether it is covered or not.
That, my lord,
12th of June.
Yeah.
Okay.
Well,
Matter is
obliged.
listed on 12th. Yeah, stop going.
Lordship, matter relating to non-payment of contractual pay, Lordship. Use Lordship and
Lordship, base to 15. Liability is 1,36,000, Lordship. Lordship, we dispose of this case in the line of contrary. The chief engineer will examine the case and Lordship.
Right, heard Learned Counsel to start. Better. Okay.
Obliged, Lord.
May I please, your Lordship? Lordship, kindly ask about the matter for the time.
Extra copies
Request
have
is
not been made
by
available,
counsel
my lord.
to the
If they may
petitioner
please
to
be
pass over
directed.
the matter for the day. Matter be listed after 1 week.
Extra copies they've not made available.
Did not pay, they'll face consequences.
My lord.
After 1 week.
Obliged, your
Yes.
Our affidavit has not been.
What affidavit? By whom?
Lordship, kindly peruse the last order, my lord.
Yes, respondents, who's there?
We written to them, received no response so far. Oh, my lord, there is a piece of instruction, or I'll file the affidavit, my lord.
You have already been permitted 6 weeks earlier.
Last chance, my lord. One week's time, my lord.
Mr. Das
Yes, sir.
That's
I'm
from-
appearing on behalf of the
appears on behalf of the petitioner and and Mr. Sharma appears on behalf of the respondent. He submits
Truth
the
free.
instructions have been received and she would like to file the affidavit within 2 weeks. Matter be listed
Deeply obliged, Lord.
after 3 weeks, enabling the respondents to file their affidavit. Right. Yeah. None appears to be listed next.
Can be taken after some time, my lord. In fact, my lord, the impugned order has been recalled, my lord. I will hand over that particular document, my lord.
Some other day next.
Mr. S. Bora, Learned Standing Counsel, submits that the impugned order dated. What is the order dated?
My lord.
Sixteen, 12, 22.
16/12/2022 has been recalled.
Has already been recalled.
Has been recalled. We'd like to place the copy of the order before this court. Mr. S.P. Roy. Let the matter be listed next week.
Lord.
I know it's in my case. My senior is in another
Is submitted, matter be listed next week. Next week.
not
Next week.
90% for
Not time being, next
timing.
week. Next week. Please inform him. Good night. No. It is to matter. Monday this week. In this matter. What is your plan? An appeal next week.
Please, your lordship. Lordship, in this matter, the government has filed their affidavit, but they have not served us the copy, lordship.
Yes, governments, please serve copies on the respondent. That's the requirement of the rules. Have you received copies?
Yes, my lord.
You have to file any reply?
Not required, my lord.
Not required. All right. Let copies be served on the private count.
No, on
Counsel
the
appearing on the private respondent.
on
Matter be listed.
APDCL, my lord. Copy may be served to APDCL, my lord. Standing Council APDCL.
Standing Council APDCL. All right. Matter be listed after 1 week. This is the case of electrical accident.
And it was admitted, my lord, the accident has occurred for the fault of the AVDCL. My lord,
If you have an extra copy, why don't you serve him?
I'll
You serve.
my lord, then at 2, my lord,
Not to, next week.
Monday, my lord,
Wednesday.
partner.
Based on Wednesday.
At least 1 week may be given, lordship. We have to take instruction if
They will require instruction. 19. 19. Matter be listed on 19.
In this matter, the respondents have filed their affidavit, but in the meantime, there's a development in the sense that the chief engineer has called us to have a discussion regarding the interest component, how much we are willing to give up and things, something like that. So let it come after the vacation slot. In the meantime, I think something will, we had the first meeting, we are supposed to have another meeting. So
it is submitted that there is some parties between the parties outside court for an amicable solution. The grievances projected by the writ petition. Learned Senior Counsel and Zarika, counsel appearing for the petitioner, submits that the matter be listed after 4 weeks.
after summer vacations, I think that's it.
Yes, listed in the last week of July.
Yes, doctor.
Last week of July 2024. office recording.
Obliged.
This matter, my lord, we have filed the inspector report today, my lord. That is not on record, my lord.
Electrical accident.
Yes, yes, I have
Submitted by
filed
the
the copy
government
today.
that the affidavit is filed, enclosing the report of the chief inspector.
My
Chief electrical inspector.
electrical inspector.
So, Mr. So-and-so appears from the APDCL. You have received copy. So, the respective councils will be served the copies of the affidavits stated to have been filed by the government today. Matter be listed after 2 weeks.
Obliged.
Very quick, your lordship. Lordship, my senior is on his legs at court number 10, lordship. Lordship, my senior is at legs.
All right, after a week.
Lordship, could a date be fixed in the next week?
Very difficult to, we can fix a date in July if you want.
Maybe after a week. After a week.
After a week. Matter be listed after a week.
Achha.
As it is submitted to the arguing council, not a bit.
Lordship, Mr. K. Chaudhary appears in this matter, Your Lordship, and he's on legs in court number 1. Kindly pass over the matter for timing.
Yes.
We have not yet filed the affidavit, my lord. I have received the instruction, my lord. This is matter relates to construction of the flyover, my lord. And out of the 6 petitioners, my lord, 3 petitioners, my lord, came to a negotiable settlement, my lord, for outright purchase. 2 of the petitioners has already received, my lord, amount. They filed an undertaking that they would withdraw the petition, my lord. I received the instruction today, my lord. And another petitioner number 2 also, he will receive. He has already agreed to the proposal of outright purchase, my lord. So, my lord, 3 weeks time, maybe granted to file the affidavit, my lord.
All right, Mr. J. Chutia, Learned Council, appearing for the KAAC authorities, submits that he's been posted with the instructions. He'd like to bring it on record by way of an affidavit. He prays for 2 weeks.
3 weeks time, my lord.
3 weeks time. MS Mohanto,
Yes, sir.
N.
Mohanto.
N. Mohan, Learned Council, appears for the writ petition. Let the matter be listed after 3 weeks. Interim order passed earlier will continue. Let the matter be listed on 22nd July. Interim order to continue till the next date of listing.
In this matter, my lord, we have received the writing copy today, my lord. Yeah, give us 2 days time to file affidavit. If possible, today we check out.
MSM Bormon, government advocate, submits that instructions are complete. She has
Affidavit
is
ready to file.
ready to be filed, and she'd like to file the affidavit within a day or 2. In that view of the matter, let the matter be listed after.
In the meantime, lordship, they may not take any coercive step, lordship, against me, lordship.
After 1 week. After 1 week, Mr. Loskor appears for the writ petition. Matter be listed after 1 week. And coercive action, we don't know, already 60% has been completed.
Lordship, still, lordship, they have not touched in our.
If there is a problem, you come with a IA, we'll see.
Right.
Otherwise, matter is listed after 1 week.
Lordship, this is an ex gratia payment contempt case, Your Lordship. The money has been released to the petitioner, Your Lordship. The bank details are also given. 2 lakh ex gratia amount has been released in the name of the bank account.
This contempt petition was filed alleging willful disobedience of the order dated 27/5/2022 passed in WPC 7142 of 2021. And stop. The Learned Standing Council Revenue,
Yes, Your Lordship. My name is not in the
M-
Vakalnama of the instructions.
MSN Bordoloi, who submits that the payment as directed to be made to the petitioner has already been released. Stop. An amount of rupees 2 lakhs have been already released.
Yes, yes, yes. Your Lordship.
Deposited in the account.
Yes, Your
Has
Lordship.
already been
The account
released and
details are
amount
there in the column, in third column.
deposited in the bank account of the petitioner. Stop. She has placed a copy of these instructions dated 7/2/2024. The same is retained in the case report. In view of such submission, this court does not consider it necessary to proceed further in the contempt petition. Accordingly, the contempt petition stands closed. Notices issued are withdrawn. Disposed.
Fifty-three, Your Lordship, I am appearing. Here also, Your Lordship, the money has been deposited in the bank account of the petitioner, Your Lordship. I have it. Also 2 lakhs rupees ex gratia grant. The communication dated 2/5/2024.
Direction contained in the order dated 14/11/2022 passed in WPT 7177/2022 have been stated to have complied with by releasing an amount of rupees 2 lakh into the bank account of the petitioner in order. Copy of the same order dated 30/04/2024.
No, Lordship, it's 2/5.
2/5/2024 is placed before the court by the counsel representing the department and taking into account the submission made for the 14 review that further proceeding carried out. Contempt that's closed. Therefore, three of the instructions is retained in the case.
Deeply obliged.
As per office note dated 27/5/2024 notice on the sole respondent has been rendered undelivered an answer. Petitioner is directed to take fresh steps, the corrective steps. List after 4 weeks.
My lord, in this case, I am appearing for respondent one. In fact, my lord, this contempt has been rendered infructuous, my lord, because the order, my lord, which was alleged to have been violated, my lord, passed by the register, my lord, has been upheld by this honorable court in a connected writ petition.
Which is the order?
Yes. No, edition register. My lord, the order of 18/3/2003, my lord, to 2023. By this order, my lord, in fact,
page number.
Last page, my lord. Of the contempt application, my lord. 30, I think it's 38. 55.
38. No, where is the order of the High Court?
Sorry. My lord, I am flipping the order. In the connected application, my lord, this order was passed.
No. This contempt is filed for non-compliance of which order?
My lord, in fact, there was an interim order passing certain orders, my lord, saying that no coercive action, my lord, would be taken. Now, my lord, while that order was, my lord, on, my lord, this particular order of 18.3 was passed by the register dissolving the boards. Now, against that dissolution, writ petitions were filed, and separately, parallelly, the contempt applications were filed. Now, in those writ
So
petitions,
you mean to say that in spite of the interim order, the board was dissolved, which
No.
is why the contempt was filed.
yes, it was there, my lord, understanding that, my lord, the interim order was to the effect that not to dissolve the board. But the honorable court was satisfied that it is not in respect of dissolution, my lord. So the dissolution was upheld by, I have placed that order by this honorable court. Dissolution was upheld, and therefore, my lord, this order passed by the register, my lord, has also been upheld.
This will have to be looked into properly. Who's for the petitioner?
Is Mr. S.K. Das, my lord, his name has been shown, R. Karim S.K. Das.
None appears for the writ petitioner. Matter be listed next week. After 1 week, on a date to be fixed by the registry. Let it come. Mr. S.K. Talukdar appears for respondent.
1 mile.
1.
Obliged.
After 1. Yes,
In this case, we are praying for 2 weeks time.
Mr. S. Dr. appearing for
Respondent number 1, Lordship.
respondent 1 submits that you have received instruction.
Also, one active instruction, they fix time to pass an effective compliance order, Lordship. We have filed an affidavit.
6 further 3 weeks time to complete his instruction. List after 3 weeks.
Obliged.
MS and Bortolo for respondent.
Made to your Lordship. Your Lordship, I have received instruction that the department is willing to comply with the order. Only thing they're seeking, Your Lordship, 3 weeks time, and then day after they will submit the compliance report. Exactly.
My lord, date may be fixed up, but they also
Yes.
take, yes,
Mr. R. Sharma appearing for the respondent submits that
1.5 years have gone by since passing of the.
department is proceeding to comply with the order. We are recording it.
Yes.
And he therefore seeks further 3 weeks time. to Complete the process. Mr. B.J. Ghosh, and counsel, appears for the writ petition. Let the matter be listed after 3 weeks. In the matter be listed in the month of July
Lordship,
on a date to be fixed by the registry.
Lordship, if your lordship kind enough to fix a date, otherwise very difficult, man.
19.
Obliged, quickly.
Mr. Lordship. Lordship, we need 2 weeks time to complete the respondent 1 and 2, my lord. From the source, we come to know that the earlier incumbent, that is respondent 1 and 2 was transferred, my lord. So we need 2 weeks time to complete the respondent 1 and 2.
Counsel for the petition. Week for the time. Necessary for completing the respondents.
1 and 2, my lord.
Completing fresh incumbent. In case of respondent 1 and 2. Prayer made is allowed list after 4 weeks.
May I please the lordship? Strike up for him. Right, just strike up for him. Strike up for him.
Yes.
May I please the lordship? Lordship, kindly, respondent number 9 and 10, kindly may strike out from the list of the respondent. Otherwise, service completed.
I'm
Your
appealing.
9 and 10,
Your name?
ATM Hussain.
So you have filed some application. You have to file a mention memo, not write an application. You normally file a mention memo for listing.
No, I have filed an application to the joint register.
Not necessary. You mention it before the court for listing. Filling up a mention memo.
My lord. So this two respondent kindly may strike out from the list of the respondents. Actually,
You file an application, proper application. File a proper application with passport. All right. Counsel for the petitioner, Craig Liberty, file proper application for tracking out names of respondents.
9 and 10.
9 and 10. How much time do you require?
3 days. Within 3 days,
Matter be listed after 10 days.
If my senior is leg on another court, kindly may be allowed filing.
They have filed an IA for amendment, my lord, amendment of the petition.
Third, counsel for the party issue notice independent of court. MSM 414, respondents
I am for 5, my
5 and 6.
Eight. One,
Mr.
one,
A,
I have one, two,
30
and
for,
three. And for one,
you're
two,
not there, sorry. MSD Bora for respondent
one, two, and
1,
three.
2, 3. And Mr. Bhattacharjee for 4. Since the council have represented the respondents of the parties notices the way the our extra copies be furnished in the period of 1 week, 2 weeks from today. Matter be listed. If respondents are able to file their objections, then matter be listed the month of July.
As per official services awaited upon reference number 3.
Respondent 3,
Respondent, private respondent.
take Dusty.
Only just 2 weeks has been happened, Lordship.
Huh?
While granting interim order, matter was directly listed after 4 weeks, but in the order, it has been short date has been given. So therefore, matter has been listed.
No, sorry, I didn't get you.
While dictating the first order, Lordship, granting interim order, directed to list the matter after 4 weeks, but due to wrong date given by the matter list early.
Matter be listed after 4 weeks.
Yes.
Await service report of respondent number 3.
Yes.
Matter be listed after 4 weeks. Mr. Foreman appears for 1 and 2.
Yes, my lord, we have received instruction, file affidavit in the meantime.
He submits that instructions have been received. He'd like to file affidavit in the meantime. You are appearing for 1.
1 and 2,
Registrar also.
register.
1 and
1 and
Interim to continue.
interim order pass. Continue.
obliged.
Yes.
My lord, I am on the behalf of the petitioner. My lord, we are no more in the case.
You filed application. Have you filed
My senior have filed it.
application before the registry?
Petitioner has already taken brief from my senior. Application, I don't know.
Do you have
My
a,
lord,
Newly engaged.
you are the newly engaged, okay. Your name, madam?
DGP, Deepegu.
MSD Pegu Learned Council submits that she that the writ petitioner has taken away the brief from her, and therefore she is no longer in the case and seeks liberty to withdraw from the case. On the other hand, MS,
We have the instruction to withdraw the
oh, you have withdraw MS so and so Learned Council appears in the writ petition submitting that they are the newly engaged counsel. So he however submits that the instructions are received from the petitioner that the matter has been settled out of court and therefore they do not wish to proceed in the writ petition any further. Accordingly, the same stands dismissed on withdrawal. MS M. Bormon
1 and 2.
appears for respondent 1 and 2. Interim orders, if any, stands vacated.
Obliged.